Please rise. The Justice of the Appellate Division, Supreme Court, first call. He, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Welcome to the Appellate Division First Department. We have almost 5.5 hours of argument time requested, so only ask for the time that you need, not the time that you want. We are familiar with your briefs and your records, and if we have further questions, we will keep asking them. People versus Hatcher, appellant. Submitted. Guzman versus City of New York, appellant. City?
City respondents, 4, Your Honor.
And Paribas?
5 minutes, Your Honor.
6 and 1, 4 and 5. Liam? Appellant?
Yes, Justice. 4 and 1.
And are you ACS?
Yes, respondent requests 5 minutes.
4 and 1, 5 and 5. Pyle versus 260, 261 Madison?
Appellant requesting 3 and 2, please. Respondent Skyliff requesting 5, please.
Did you talk with each other at all? Because you all have the same exact position in terms of whether one would argue for the other or...
Discussed, Your Honor, and we have, I'm going to be addressing 302A, 31, and one of my colleagues will be addressing 3.
Do all three of you want to argue, though? Okay, go ahead. You're requesting how much time? Okay, 3 and 2, 4, 4 and 4. Ace American versus Consolidated Appellate, Edison, appellant?
Yes, Your Honor. Requesting the full 15 with 12 and 3, please.
Con Ed? City? 6, 1, 6, 1, and 5. And again, if we have more questions, we'll keep asking them. SolidX Management versus VanEck Securities, appellant?
Appellant requests 5 and 3, Your Honor.
Respondent? 5, 2, and 5. People versus Maximo, appellant? Respondent? 4, 2, and 5. Keang? ACS?
Respondent, Good Shepherd Services request 5.
Sorry, you're not ACS. And you're here for the child?
Yes, respondent attorney for the child, 4 minutes.
5, 1, 5, and 4. Hutchinson versus Brown? Submitted. People versus Hay? Submitted. Lowe versus Lowe. There are 2 appeals, just so you know, they're both going to be heard together. So the time is going to be for both of the appeals.
Thank you, Your Honor. 5 and 2, please, for appellant.
Respondent, Allison Lowe, 3 minutes.
And you want 5. Okay, 5, 2, 5, and 3. Mazone versus Alonzo Andalcar. Just so you know, I did give time, but I'm not going to give time to both the plaintiffs separately. So one of you get to argue, because it was a courtesy to give the time, and I don't think you both need to argue. It's the same position.
I respect that, and then 27 and 3, joking.
That it wouldn't even be allowed.
8 and 2, Your Honor, maybe 9 and 2, but it's the end of the day when I get there, so it'll be up to the panel. You can cut me
Okay, and you're the respondent? 5, 1, and 5. And again, for all these cases, if we need more time, we will keep asking questions. Guzman versus City of New York.
Good afternoon, Your Honors. May it please the court. Michael Zhu, I'm appellate counsel of the Guerrero and Rosengarten, attorneys of record for Mr. Eduardo Guzman. The judgment appeal from should be reversed on 2 issues. One, as to Palabras, we believe that the appeal is proper because it takes an appeal from a final judgment that brings up for review.
Even if the appeal is proper procedurally, how are you going to deal with the issue of proximate cause and that the car was stolen days before the accident actually occurred, therefore arguably severing any proximate cause?
Well, the problem with that defense is we don't know what happened to the vehicle for those 2 days. So,
Well, we know it was stolen and that they were not in possession of it for those 2 days.
but it could have been out of possession and just sitting there for the 2 days, and then the incident happened. So it doesn't matter, meaning the time here.
Why
because-
would that be relevant? What possible relevance would that have to be for proximate cause for your accident?
Well, because the proximate cause argument is, once the vehicle is stolen and it's out of my hands, I don't know what happens to it. And because it took 2 days for them to find it, I don't know what happened during those 2 days that led up to these events.
But what does that have to do with Palabras?
Oh, because he allowed the vehicle to be stolen. I'm sorry, let me take that back. His negligence caused the vehicle to be stolen.
He reported it stolen 2 days earlier. Whatever was happening with those cars for 2 days, they reported it stolen 2 days earlier. So where is the proximate cause between the car being stolen and the accident occurring?
Right, but the point is, forgetting about the 2 days, let's say it happened immediately right afterwards, the same proximate cause defense is still there. So meaning the defendant can still argue, hey, the car left, was out of my possession, I didn't have anything to do with it, and something happened to it. So it really doesn't matter that the vehicle was stolen 2 days before, so that timing issue isn't.
So under that argument, a month goes by, you would still say that you have a proximate cause argument?
Yeah, I don't-
Where do we draw the line, I guess, is the question? Because under your argument, it seems like there is no line drawn.
Well, I'm saying you shouldn't draw it at 2 days, but
Well, then where do we draw it? Tell me, where do we draw the line?
I don't know the answer to that, Judge.
Why don't we address the city for a moment?
Okay.
As to the city, there's an argument as to whether it's the reckless disregard standard or the negligence standard. But how do you win under either standard, I guess? Because if it is under
How do I
either,
what? I'm sorry?
win under either standard.
I don't
If-
have
if
to
it's-
win under either standard. I didn't
How
move for
how do
senator.
you win, oppose their summary judgment under either standard? If it's a reckless disregard, how do you raise an issue of fact? If it's negligence, how do you raise an issue of fact?
Well, it's an interesting case because the testimony conflicts with the theory. The testimony was, we didn't engage in a pursuit. We followed the vehicle. Our police patrol guidelines tells
Okay, so
us.
that's
Let's say it's negligence, right,
That's
so let's say it's negligence. If the standard is negligence and they weren't doing anything incorrectly, they were just slowly following and not speeding or anything, what's the negligence?
the following. If the patrol
Why
guide
is it
says,
negligent just to follow if they're not speeding or going through any lights and they're just following? What's negligent about that?
but there is an issue there because if you look at the video, they certainly were not following. The video shows the end of it. It shows the car turning, making the right turn and striking the plaintiff's vehicle. And then
I
within
watched that video. I think it absolutely shows they were following the car. That's what they are paid to do, is to follow the car that's stolen. But they didn't they didn't run any red lights or anything like that. So where is the negligence?
the negligence is that following. If their procedure
Why is it
That's
negligent
their
to
job.
follow?
That's
What's-
their
No, I respectfully disagree because if their procedure is we are not to follow stolen vehicles, and the reason why they do that is a pretty good reason because things like this happen. So if the procedure is we don't follow and we just let them go, but
Where's
that's not
that
what they did
procedure?
here.
Wait, where's the procedure that they're not supposed to, they're not supposed to ever pursue a
It's in the
stolen?
testimony, Judge, from both Fox and Walsh. They both testified. Procedure is to not follow, not pursue, just to let them go because things like this will happen.
I don't think that that's what the testimony was, number one. They basically said, they had their red lights on, they were behind them, and they're not doing a high-speed chase. I agree with you that they both agreed to that, but not that, no, we don't ever pursue people in stolen cars. I don't think anyone suggested that that was.
I believe Detective.
Oh, okay, well, I'll ask the city.
If that's the policy, then the getting into the vehicle and following and
Even if
continuing.
that's a policy, what, your argument is that the failure to follow the policy is a negligence?
No, the failure to, yeah, correct. The failure to follow their policy is evidence of negligence. I didn't move for summary judgment, so I'm not saying I win on this. I'm saying I'm entitled to go to a jury on this
Do you have
issue.
a case that says the failure to follow a policy articulated in testimony is negligence?
It's evidence of negligence, Judge. I never argued in the papers below that it's negligent, and therefore I'm entitled for the court to search the record to grant me partial summary judgment. I'm opposing their motion. Their motion, they argued, we have reckless disregard standard here, we win. They don't, because there is no reckless disregard. So they don't get the benefit of that 1104 statute.
Okay, you'll have time on rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Philip Young on behalf of the city respondents.
You want to address this policy?
Yes, so what the testimony was from one of the detectives was that NYPD policy is not to engage in high-speed chases. That's all they testified to. What they testified was that NYPD policy is when a vehicle is stolen, you follow after the vehicle, you follow in the direction of the vehicle, because usually these people dump the vehicle once they think they're out of sight of the police.
Right.
And there's,
so
go ahead, I'm sorry.
if we're taking that testimony with the video that was submitted, is there any view that maybe would support the plaintiff's position? I mean, it was about a couple of seconds after when the Land Rover turned and then you saw the police vehicle.
Yes, Your Honor. I think our view is that the video undisputably shows that the officers were doing a similar speed to the Land Rover, which exceeded the speed limit. And they were allowed to do so because they were engaged in an emergency operation of following a stolen vehicle. So under VTL 1104B, the reckless disregard standard applies in that context. And there is no evidence in here that the officers engaged in any type of reckless conduct that would put.
Can failure to follow a policy constitute negligence?
I don't know the answer to that question. I think there are other cases where failure to follow a police department's policy about not engaging in high-speed chases or not calling the dispatcher to notify them of the chase could amount to recklessness. I don't know that's ever been held that it's the case for negligence.
Is there anything in the police regulations that says you shall not follow a stolen vehicle?
Not that I'm aware of, Your Honor, and it was not part
Did
of
the
the record.
right? Did the plaintiff submit any police department regs that would say if we locate a stolen vehicle, you're not permitted to follow it?
No, none, Your Honor.
The officer was just talking about high-speed chase. Is that, I
Correct.
read
It was
the
testimony from the officer about NYPD policy not to engage in high-speed chases. And then just additionally, I also want to note that essentially all of these arguments that the appellant is making here are unpreserved. He didn't argue proximate cause in Supreme Court. He didn't argue proximate cause in his appellant's brief. He argued it for the first time on appeal, or first time in reply. And even the argument he makes about the reckless disregard standard, he didn't make that argument in Supreme Court either. What he argued in Supreme Court was that the reckless disregard standard doesn't apply because the officers were not engaged in an emergency operation. That's a position he disavows on appeal. He acknowledges, he concedes the officers were engaged in an emergency operation. So that argument is also waived on appeal.
Thank you.
Thank you, Your Honors.
May it please the court, Gerard Ferrara for respondent Palabras.
Why isn't there an issue of fact as to proximate cause?
It's funny, I'm traveling on the railroad to get to this court this afternoon for this argument, and it brings me back 100 years to Paulsgraf v. Long Island Railroad. And essentially, as Justice Kern, you addressed it before, there is no proximate cause to a scenario where 1210 contemplates a vehicle being stolen in pursuit or in fleeing the thief gets into an accident, an injury, or some sort of scenario occurs, which is not even close to the fact pattern here. As the whole panel is essentially addressed, the vehicles are stolen, reported stolen, 2 days pass by, and an accident occurs. I don't think there could be any greater argument for the severance of causation or some or proximate cause between the vehicle being stolen and the vehicle being involved in an accident as a result of a police chase, whether it was in the course of their duty or not. Unfortunately, I can't even address the city's arguments because because Palabras had been out of the case for years before the city even moved for summary judgment, and we weren't privy to either the motion, making an argument, and essentially at this point have no standing to address it on appeal, which again defaults to the prejudice of Palabras. We have an incident here where Palabras was dismissed in 2020. Not appellant counsel, but plaintiff's trial counsel conceded they were taking no appeal. No appeal was taken, and some 4 years later,
Are you arguing now about that we don't have the right to hear this appeal?
I am, Your Honors, because
Because isn't the rule pretty clear that when you appeal from the judgment, you appeal from any ruling along the way that's dispositive, and the ruling as to you was dispositive? So
correct.
why don't they, separate from the merits, why don't they have the right to appeal it?
Well, with the caveat that this is arguably a case of first impression, Your Honor, in the sense that we're not disputing that a final judgment appeal does consume all orders beneath it. But this is a scenario where the judgment that's now being rolled into this appeal was some 4+ years ago. As such, the legislature, as I argued in my briefs, set a 3-year statute of limitations for this. It gives plaintiffs a fair chance to bring a claim. It gives defendants a fair chance to final judgment and to put an issue to rest. The defendant was dismissed 4 years ago.
The court to make new law then about how to interpret?
It's not new law, Your Honor. I would address the fact that it could at least define or set the broad to not broaden the scope of that restrict that the defendant is now allowed 4+ years after having no involvement in a case, again, including the fact that we were not able to oppose the city's motion.
If the legislature wanted to put some temporal limitation on the right under 5501, wouldn't it have done that?
I think they arguably did, in the sense that, again, they set a statute of limitations on claims such as
That's to commence an action. That's not the timeline to appeal. That's to initially commence an action. There's no question that this action was timely commenced under the statute of limitations.
Correct, Your Honor. But again, it inures to the prejudice of the defendant, who was not given a chance to oppose the city's.
No, but all you would have had to have done is ask the trial court to enter judgment, and you didn't. I looked at the order. The order says summary judgment is granted, but it didn't sever your claim and direct the clerk to enter judgment. All you have to do to stop this from happening yourself is to say to the clerk, to say to the court, please direct the clerk to enter judgment or submit a judgment to the court. Either way, you could have stopped the clock. You could have started the clock running 4 years ago, but you didn't. So now 4 years later, you're stuck with the fact that you have a 4-year-old order that's not final. But there is a resolution to it, an easy one. The party who gets the judgment submits a proposed judgment severing and dismissing the claim, or asks the court to direct the clerk to do it.
So in this,
it's not like you're remediless.
well, in one sense we are. As I said, we now no longer have standing to address the city's motion. We also were not able
You
to.
certainly have standing to oppose the motion against you, to support the summary judgment in your favor.
Correct, but we also no longer have standing to move for default on Cabrera, who again was dismissed from this action because plaintiff failed to take a default. We would have had the option to move for default on the cross claims. But again, all of that was laid to rest by the fact that there was no appeal taken. And again, even conceding the point, should the court find that the appeal is preserved, I would argue substantively on the merits, as the bench has argued at this point. There is no causation between a vehicle that was stolen 2 days earlier and then gets into an accident. Plaintiff has essentially done nothing but speculate or offer conjecture as to where this key fob was. The record is essentially full with the notion that Mr. Romeo, who was the owner of the vehicle under his corporate entity Palabras, was aware or believed he had the key in his possession. He walked into a pharmacy, comes out, and his vehicle is gone. They all check the ticket, and again, unless the court has any questions, I'll rest at this point. I see the light is on.
Thank you very much.
Your Honors.
Just one very quick point as to the city and the policy on the high-speed chase. Council just said something very interesting just now. He said that the officers, and you could see it on the video, the officers were following the perpetrator, the Land Rover, and keeping its speed. And the Land Rover was traveling at a high speed, although not recklessly. But that raises an issue as to whether they breached their own policy of not pursuing in a high-speed chase. If the Land Rover is going at a speed in excess of the speed limit, and the officers are keeping pace, which is what council just said just now, and I believe they also argued this in their brief, to take advantage of the 1104, then I think it raises an issue of fact as to the city's negligence in pursuing the vehicle, although not in a reckless manner, but in violation of their own policy.
Thank you.
Thank you.
Liam?
Good afternoon, Justices, and may it please the court. In order to have made the finding that the family court made in the court below concerning my client, Michael Weinstein on behalf of Ms. J, the respondent appellant from the Neighborhood Defender Service of Harlem. In order to have made that finding, they would have had to have shown by preponderance of evidence the requisite level of intent under the Abuse Statute and Family Court Act 1012E. That wasn't proven in this proceeding. The testimony from Ms. J and the maternal grandmother in this proceeding reflected that they didn't know what happened, that even the doctors who both testified, now there was one doctor, Dr. Brown, who treated the child at the hospital.
Didn't Dr. Brown say that the injury could have only occurred through a twisting motion?
Doctor, please just let me know. Yeah.
Is that a fair statement?
Dr. Brown did say that with the twisting motion.
And your client really didn't testify to any. The claim was that she was holding the arms and play walking. Couldn't the court rely on the doctor's testimony to find the requisite intent that this injury would not occur without twisting?
The doctor's statement is, you're 100% correct, Justice Singh. However, that it could have been accidental as well, an accidental twisting. Now, Dr. Brown's concern...
But there was no testimony from your client that there was an accidental twisting, for example.
And this is where what may or may not have happened at the maternal grandmother's home earlier that day, even more relevant.
Well, does it really make it relevant? Because when the child returned from the maternal grandmother's home, the mother's testimony is that the child was fine. She fed him. I'm not really sure where you're going with that.
So part of the testimony from both experts is that the natural manipulations that would have occurred after the child returned from the maternal grandmother or throughout any activity during the day, the dressing, the getting ready to go to the city MD, getting ready to go to the hospital, would have moved the position of the arm. There is a possibility, and that exists in the record, where the child's arm may have been slightly fractured, and the act of play walking with the child caused even more harm, one could say, or caused even further displacement, caused the actual...
Based on what? Based on what evidence is that a possibility?
The doctor's statements that manipulations could have displaced the location of the arm.
But there's no evidence of that. There's no factual evidence of that, right? Your client did not claim that that's what happened. In fact, she claimed several different things, depending on who she was speaking to, about how the accident happened.
Well, this testimony in terms of what happened is consistent, that there was play walking and then going...
No, that's not what she told the doctor at the urgent care place. She told that doctor something else.
I think the distinction is where Miss J physically was when the play walking occurred. There was a disagreement over whether she was on the bed or whether on the floor. The testimony was that she was on the floor. But to the doctor, she said that she was play walking with the child on the bed. The distinction is that to the doctor, Miss J, in hearing how fragile children's bones are and knowing that she had engaged in this play walking, says, maybe I did it. That's one statement that is made there, but clarified in the testimony when the court held the trial as my client's recognition that she was part, potentially, of the causal events.
So wasn't the trial court entitled to credit one expert over the other, listen to your client's different explanations, depending on where she was and who she was talking to about the accident, and then find a preponderance of the evidence?
Only in making that finding of intentionality as well. There's no way to get around it, and there was no proof of intentional conduct that caused the harm.
Generally, there isn't, right? People don't generally say, yes, I hurt my child intentionally. It almost always happens circumstantially, right?
It's certainly part of the burden of proof of ACS to introduce any evidence they might have that would show that intentionality, and they did not in this proceeding here. Thank you so much.
Thank you.
Good afternoon, Your Honors. John Shep-Wong on behalf of the respondent ACS. I'd just like to just start by emphasizing what the standard is here, and that's the preponderance of the evidence, as the court knows, whether it's more likely or not that this was abuse. We don't have to exclude the possibility of other causes. We don't have to show with certainty what the mechanism of injury was, and that's the whole point.
How do you, the argument is the mother didn't intend the injury, I guess. How do you respond to that argument, that it occurred while the mother was playing with the child?
Well, I think that we have to keep in mind here that there is a burden on the mother here in this case, a burden of production to explain what happened while the child was in her care, to dispel this presumption of culpability that the Family Court Act creates based on the ACS's prima facie case, based on the evidence of the injury, as well as evidence that this couldn't have occurred, doesn't ordinarily occur absent an act or omission of the respondent. And I think that there is evidence of intentionality here, even apart from that. We have a 5-month-old who can't walk, who suffers a broken arm from a forceful impact. So and I'd like to address that torsion versus the oblique fracture here. So Family Court did find that, Family Court credited the petitioner's expert with regard to the impact here. But whether it was torsion or impact, the mother offered nothing to explain either of those theories of how this fracture occurred. Importantly, she offered nothing showing that it was an accident of any kind. She denied any kind of fall, any kind of impact. She gave this explanation where there was play walking at one point, but that only showed that the child was in her care when this injury occurred, because obviously a child would not have tolerated that sort of activity if it already had a broken arm.
And the child had been in the grandmother's care earlier on that day, but there was some testimony from the mother about how the condition of the child when the child returned, right?
Right, that's absolutely right, Your Honor. So all of the evidence here points to the preponderance of the evidence showing that the child was in the mother's care when this injury occurred. And to Your Honor's point, there's testimony from both the grandmother and the mother saying that the child was fine when he returned from the grandmother's care that morning. So from that, we know, based on a preponderance of the evidence, the Family Court properly found that this was the mother, the preponderance of the evidence supported the child being in the mother's care when the injury occurred. So I think that, that's why this debate in the papers over who was charged or who was not charged is really a red herring in this case. There's really no debate, nothing in the evidence showing that it wasn't the mother, that the child wasn't in someone else's care while the child was injured. So that really is just a red herring in terms of the charges here. But I think that what's worth emphasizing is that Family Court was best positioned to judge the credibility of the mother in this case and determine based on a preponderance of the evidence whether there was sufficient evidence of abuse and intentionality. And I think that when you look to the Family Court's presumption and you look to the nature of the injury, the 5-month-old who can't even walk, who can't inflict a forceful impact on his own arm to break it, you have expert evidence from that petitioner submitted that's showing that this type of injury is suspicious for child abuse. All of that together, coupled with Family Court's analysis of the facts as a whole, supports a finding of by preponderance that this was abuse, Your Honors.
Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court. Shreem Nothenberg, Lawyers for Children on behalf of the subject child. I think it's important to start with the very first claim that was made, which is that there's no showing of intentionality, and it could have been the walking, this holding of the child by two arms and walking that displaced this broken humerus. But let's face it, there was one expert who opined as to whether that could have happened, and that expert said, no, that is not a viable explanation, and that can be found in the record January 31st, 2022 at 22 and 25. Interestingly to note, Appellant had her own expert, and guess what? That expert did not opine as to whether that play walking could have caused the break. Nobody asked that. Certainly Appellant didn't ask that, probably because she didn't want that expert to have to answer that question. And if you listen very carefully to what Appellant has said here today, the suggestion was that the play walking somehow caused the fracture to actually become displaced. So what the suggestion is somehow it might have happened in the grandmother's care, and it was the play walking that exacerbated it. He doesn't actually say the play walking caused the break, but just that it could have been exacerbated. So the argument really is, what he's trying to say, is that it might have happened. There's a remote possibility it happened while in the care of the grandmother. Because let's remember, the child was in the care of the grandmother for a few hours in the morning and then returned to the mother's care. But as has already been recognized by the bench, the problem with that is the mother's own testimony. Because you know what she testified? She testified the baby came back, was very playful, was willing to drink a bottle. Then she was able to burp him. Then she was able to engage in this very activity of walking the child using both arms, one of which she's now contending was broken. Now, there might be some remote possibility that could have been the case and that the child didn't complain. Interestingly enough, the child did complain of pain after she put the child down for a nap. Didn't complain while being dangled, didn't complain while being burped, didn't complain while being fed. Somehow, that's the theory that is being put forth for your honors to take into consideration. I would argue that this court made a very particular finding that the child was in the exclusive care of the appellant, and the evidence was not just the expert opinions that the child's break was acute, so it happened within 7 days, but also the mother's own testimony. And mind you, there was no testimony at all from the grandmother or the mother saying that the child was injured when the child was returned. So the big problem with appellant's appeal is that it's based on two errors, one factual, one legal. Factual is that the child was not in the exclusive care of the mother. The evidence proved that, and again, it's a preponderance of the evidence. It's not rule out every conceivable possible de minimis chance of something else. It is preponderance that was found. And second of all, there's this argument that was aptly described as a red herring, that somehow the mother didn't have her due process rights were violated because the grandmother wasn't also charged. But anytime you have a due process argument, what do you need? You need to ask yourself, well, what process is being asked for? What's the additional process she should have had then if her due process rights were being violated? And you know what? The trial was full and fair. There's no discussion of what additional witnesses she would have brought, what more testimony, what more documentary evidence. She had a full and fair trial at which she was able to demonstrate that the child was not in her exclusive care. She was not able to overcome ACS's, the city's evidence that she was in fact the child was in her exclusive care. Now, 1046, the point of the statute is to say that's not true, is often the case, you're not going to have somebody say, well, what actually happened is I got really angry at my child because he wouldn't stop crying and I punched him. Not going to happen. 1046 allows for the city to make a finding of abuse based on the type of injury that wouldn't have happened but for an act or omission by the parent and the fact that the child was in the exclusive control of the parent. We have both of these here. You know what? Liam is only 5 months old. He can't walk. He can't even sit up. He can't articulate what happened to him. It was only the mother and Liam.
There have been an accidental twisting?
Excuse me?
There have been an accidental twisting in this case that caused the injury.
By the testimony of appellant's own expert, it wasn't even accidental. It was an impact. It was an impact. There could be an accidental, but you know what has to happen in that case for 1046? For a parent not to have a finding of abuse, they would have had to come forward and talk about the fact that they accidentally were, the child was in the crib or was going to be in traffic, and you grabbed your child very, quickly in order to protect the child and the arm got twisted. That's what the purpose of allowing the parent to come forward with an excuse. You know what? We don't have an excuse here. Nothing the mother came forward to say explained this injury. Therefore, 1046 is what allows for this abuse finding to be upheld. Thank you.
My colleague from across the table cites two specific pages from the January 31st transcript concerning Dr. Brown. The exact quote from Dr. Brown on page 16, which is before that, is that no fractures prove abuse per se. On page 22, she brings up what we discussed before over Ms. J's statements, but also says on page 23, this is Dr. Brown, that if the child slipped, he could have been injured in this way. The concern for abuse came from the misconception that the child also had a broken leg, that no explanation at that point had satisfied Dr. Brown, given what she believed concerning the leg and the arm. But we cannot live in a world of speculation, and that's what happens if we're trying to infer intentionality here, where Ms. J truly doesn't know.
How do you account for the injury then in this instance?
Part of it is the non-exclusivity of control. There was an exclusivity that was shown. The child was with his grandmother in the hours preceding when Ms. J observed that he was injured.
Thank you.
All right, thank you, Justices.
Heil versus 260, 261 Madison.
Good afternoon, Your Honors.
Let them just
Oh,
see the-
I apologize. My bad. I apologize to my counsel and to the court.
Okay.
Good afternoon, Your Honors. May it please the court, my name is Howard Altman for Appellate Marine. Your Honors have hours of argument to look forward to today, so unless you have any questions for me at this point, I will defer into my reply.
I'm sorry, you'll what?
I'll defer into reply. I could rest on my opening brief and spare you guys some time unless you have any questions for me at this point.
We'll wait for the rebuttal.
Trying to save you some time.
Okay.
May it please the court, my name is Steve Kaplan. I represent Skylift. There is personal jurisdiction under both CPLR 302A1 and 302A2. I'd like to address 302A1 and defer 302A2 to one of my colleagues. The statute requires that the cause of action arise out of one of the acts enumerated in the section where the defendant commits a tortious act outside of the state, which causes personal injury inside the state. Where the defendant does or solicits business within the state or engages in any other persistent course of conduct in the state as...
How do you establish the soliciting business aspect in this case?
Well, I think there's ample evidence of that, Your Honor, from between the years 2014 and 2018.
So in this case, the sling was sold in 2008, correct?
That is what is in the record,
Okay,
although
so-
subsequent
so it would be a
depositions
fair
indicate
statement to
otherwise.
say that. So why should we look beyond when the sling was sold to make a determination whether or not Marine would have reasonably expected the product ending up in New York?
That's a good question, Your Honor, and I believe that Section 302A31 does not impose a reasonable expectation or requirement. That is a subject of 302A32. Under 302A31, it's sufficient that the defendant regularly does or solicits...
Okay, same question. Why should we look beyond 2008? Should we look... 2014 seems years and years after the sling was sold. Why should we go that far to determine whether or not there's jurisdiction?
My understanding is that the most important year is the year in which the suit against the defendant was commenced, Your Honor. and the third-party suits.
What case would tell you that, as opposed to the year that the product was manufactured, and that in that year, or when the product is manufactured, that's what we're talking about, right? So the question is, at the time I made this sling, did I anticipate that I would be brought into court in New York? Why would, have you seen any cases that would say any other thing than that?
Well, I haven't seen any case, Your Honor, that imposes an anticipation requirement on 302A1.
Have you read any of the Supreme Court cases?
I have.
And all of them, I mean,
I have,
Bausch
Your
and
Honor.
Lamb, all of them, that's exactly what they're talking
The
about.
most recent of those is the Ford case. Your
Right.
Honor. And
Exactly.
the Ford case holds that there need not be any causation between the manufacturer
That's a
of the
completely
particular
different
vehicle.
prong than whether or not I'm doing something in the state at the time I manufacture the product that would give me some idea that I could be hauled into that state. And how about our gun case, the New York State Court of Appeals gun case just recently?
Your Honor, all the cases I have seen involving, most of the cases involve 302A1 or 302A32, which is a very different standard.
Well, let's just assume that we're talking about the year that the product was made. Is there anything in the record that would show that there was substantial business in New York in that year?
Assuming the product was made in 2008, no, Your Honor, there is not.
Thank you.
Thank you.
Good afternoon, Your Honor. May it please the court. I represent defendants, second, third-party plaintiffs, third-party plaintiffs, and fourth third-party plaintiffs, 260, 261 Madison Avenue, SFM Construction, and ASRR Construction. Under CPLR 302A32, it's our position that the appellant should have reasonably inspected that its sling would have consequences in New York because it was indirectly serving the New York market by selling the sling to
So you're saying that in 2008, when the sling was sold to Paul's, that Marine should have reasonably anticipated that the product would end up in New York?
Yes, because Paul's was one of the Marine customers that had in its very name the information that this product would be resold and that Paul's was not the ultimate user of that sling.
That it would be resold in New York or just resold?
Well, because of the proximity of Paul's to the New York City market, it's only about 83 miles from the city. And the fact
Is it in New York?
No, Paul's was based in Branford, Connecticut, and
so your position is that Connecticut is close enough to New York that we will have jurisdiction based on that?
Yes, and the admission by the president of Marine that its products were mobile, and that it would sell products knowing that the product would be bought in one state and would travel to another state. And
what case from either New York state courts or from the United States Supreme Court indicates that it's enough for a forum state to impose its personal jurisdiction if an adjoining state has personal jurisdiction over the party?
Well, there were a number of cases cited in my brief about the product being manufactured in one state, sold to another state, and being involved in a tort in a different state. And the long-arm jurisdiction and due process elements were found to be satisfied.
But those cases are not talking about the fact that it's near the other state. None of those cases have anything to do with the fact that the state in which it was sold was near or adjoining to another state. There are other things that they're talking about. But I mean, did you cite any cases where the proximity so essentially that would be every state that connects to New York, including Canada, I guess, New York would have jurisdiction if anything was sold in any state that touched New York. But I don't think that I've seen any cases that say that.
Well, the ABAR case from the Second Department from 2022, the car was sold in Ohio and then involved in an accident in Virginia, and long-arm jurisdiction was found.
By the fact, because Virginia is close to New York?
No.
Right.
We actually say in Cruz that the mere fact that a product may make its way into New York is insufficient by itself to establish jurisdiction under 302. Isn't that what Cruz says specifically?
I'm saying that Marine had more than a belief that it was a mere likelihood that this product would wind up in New York. There's
no evidence it was actually selling very much or doing much business in New York, if at all.
That's true, Your Honor.
So the only way it would expect it is if it's sold in another state. You're saying the fact that it was sold in Connecticut creates an expectation that it may end up in New York, but don't we specifically say in Cruz that that's not enough, the mere possibility that the product may end up in New York?
Yes, the mere likelihood that it would wind up in New York is insufficient, but...
Isn't that what you're really arguing now?
I'm sorry?
Isn't that what you're really arguing? Because it's sold in Connecticut, there's a chance it will end up in New York?
Well, I'm saying because it was obvious that Paul's was going to resell this product.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. Michael Shacker for Defendant Respondent Haynes Supply. Just to touch on Your Honor's point regarding case law with regard to sales being made to a neighboring state, the Kieran v. Kurtz Hastings case, Western District, 1998, specifically held that a Japanese manufacturer that sold to a Pennsylvania distributor could have and the product was ultimately resold to New York, could have reasonably foreseen that that product would make its way into New York.
The circumstances of those cases, the circumstances here, namely that a product is sold in Connecticut in 2008, Marine years later does some business in New York. Shouldn't we be looking at 2008 and not what happened years later?
I understand Your Honor's point with regard to that, but the case, as Mr. Kaplan indicated, there are several cases which point to the important date being prior to the commencement of the lawsuit. And here we do have multiple sales into New York. We have 2 sales into New York prior to the lawsuit being filed. We have, as I noted in my papers, sales to Granger in New York, so we have direct sales into New York. Furthermore...
So then how do you deal with Cruz? Because in Cruz, don't we say something different?
I'm not sure of the holding in Cruz, Your Honor.
And are any of the cases that you cited post sort of the Supreme Court revisiting this issue in 2015 and everything that came out of that? All those cases that you cited are pre that era, correct?
That's correct.
And the landscape has changed enormously since then, correct?
That's correct, Your Honor, but there's, the Kieran case, the Adams case, the Allen case that we cited, the Philip Morris Fellas case, all those cases, they have not been overturned. They're still...
I mean, because they're not going to, but the law is much different now than it was in terms of what would support long-arm jurisdiction than it was when those cases were decided. Do we agree on that?
I agree, but each case is factually different. And here we have, not only do we have the sales directly, but we also have contracts with Haynes prior to the lawsuit being filed.
Yeah, but I don't think that is what the courts are looking at anymore. They're looking at, for example, the Bausch and Lomb case and all those cases, they're looking at the time the product was sold. I mean, eventually, most products are going to make it through that kind of product anyway, through resale to 20, 30, 40 states. And it can't just be that years later, because of a resale and increased business, that long-arm jurisdiction exists.
Well, just to play a hypothetical, if hypothetically speaking, if a sale was made in 2008 and then the companies, say Marine or any other company, continuously markets into New York.
But that's not what we have.
That's not this case.
Well, they do, though. That is, I think I respectfully disagree, because we have here Marine.
What's the evidence of continuous marketing in New York in this case?
Because Marine sent employees to expositions in Buffalo in 2017, and then 3 months later, they're selling products to my client.
That attending the exposition, was that for marketing and selling purposes, or was that for something else based upon the evidence?
It was absolutely for marketing purposes. Specifically, Mr. Benton, Marine's owner, testified that he sent 2 individuals up specifically to glad hand, pass out business cards, and ultimately conduct business and make sales. And then that's exactly what they did. They made
The argument is hard for me to grasp because what we're talking about is something that happened in 2008, and whether in 2008 Marine would reasonably expect, and now you're asking us to look at what was occurring in 2017 to say back then they should have expected the sling to appear in New York. That's what you're arguing.
I understand that, but the fact is they were making sales, as Carol Lee mentioned, right outside of the city. So if we want to go back to 2008, fine. They were
Right out of the city, in Connecticut is what you're referring to.
Yeah, 80 miles outside. And in fact, the subject sling did make that stream of commerce route. It was sold to.
So where do we stop that then in terms of the proximity argument that you're making? 80 miles is sufficient, 40 miles, okay, but 90 miles maybe not? I mean,
I think it goes to the reasonable foreseeability test. If it's, selling something.
That is antithetical to Walden versus Fiore, which stresses that we have to focus not on the foreseeability of being hailed into the forum, but the defendant's contacts with the forum.
I understood, but we have the minimum contacts here. Prior to the lawsuit being initiated, the expositions, the trade show.
Again, let's talk about in 2008, what contacts were there that at that time, that company would expect years later to be brought into New York?
Thank you.
Thank you.
Your Honors, I addressed respondents' arguments in my reply brief, so unless you have any questions.
Yeah, I have a question, sir. Tell me about the product sales that were made in New York between 2014 and 2018.
There were 2 sales, one to a company called Edo Corp for an aluminum eyelatch, and one to Haynes. They totaled $400 between the 2 sales.
So let's assume that we agree with your adversaries that we should look at what occurred between 2014 and 2018. Is that sufficient?
No, the courts.
Find jurisdiction.
I apologize. Sorry for cutting you off, Just. No, the courts, both this court and the United States Supreme Court, have held you need more than isolated random sales. They held 2 sales was not enough. The U.S. Supreme Court said 1 sale is not enough. It needs to be some type of substantial systemic intention of targeting New York.
And between
2008 or 2014.
So 2014, 2018, 2 sales, what percentage of the sales of the company did those 2 sales make?
Less than 1%. Total sales.
Less than 1%.
1/10 of 1%?
$41 million.
Any more questions? Thank you.
Thank you for your time, Your Honors.
Ace American versus Consolidated Edison.
May it please the court. Erica Kirstein for Ace American Insurance Company. Seeking for the court to re-review the trial court's decision that Ace has a duty to defend the city and Con Ed here. There's a lot of questions and a big record before your honors, but the main question is, can you actually find that Waterworks was even potentially the proximate cause of the accident?
How can we even reach that issue at this point? How can we make that decision? There's no underlying decision in the underlying personal injury action. Isn't that premature? So shouldn't we be looking at the 4 corners of the complaint to make that decision as to whether or not there's a duty to defend?
Looking at the 4 corners of the complaint, you could make the decision there's no duty to defend, but Ace had other information.
How do we reach that conclusion?
Because the complaint does not allege that Waterworks was in any way negligent for this accident. The complaint alleges that Mr. Rodriguez hit a live wire and was electrocuted, and that live wire was in the exclusive control of Con Ed and the city.
So isn't it the reason why that's not alleged in the complaint, but could be alleged in the cross claims, because the plaintiff can't sue his own report, right?
Precisely.
We're talking about all the pleadings, not just the complaint, but
Assuming it is in the four corners, then, and that would be, if you just looked at the complaint, it'd be enough. I think the argument you're making is to look to other evidence in the record to support your argument that there isn't a duty to defend. But this isn't the underlying action, it's a declaratory judgment. So wouldn't we need to have some kind of definitive ruling in the underlying action, such as summary judgment or something which definitively decides this before we could possibly hold there's no duty to defend?
For indemnity, I agree with you. For the duty to defend, there must be some limit to that. And we have to continue.
The limit is the complaint.
Well,
normally you look to the four corners of the complaint, and if you can gather it from the four corners of the complaint, which I think you can from this action, then there is a duty to defend. So why are you accepted from that in this case? Why isn't there a duty to defend? Because it is alleged in the four corners.
it's not alleged in the four corners, but the problem is Ace picked up the defense even though it wasn't alleged in the four corners of the complaint. And Ace picked up the defense.
But I think you're being overly restrictive. When we're talking about the four corners, we're talking about the pleadings in general. And don't the pleadings here, when you look at them, isn't there sufficient allegations that Waterworks may be culpable, maybe not as much as Con Ed? For example, there's a question about whether or not there were safety gloves.
Well, those are not in the four corners of any of the pleadings.
Wait, are you arguing that we're only supposed to look at the main complaint and the main action?
Well, there was no other complaint
because the employer is never going to be sued. So if there's an argument to be made that the employer can be liable, it will never be in the main complaint. If we accepted that argument, then there would never be a duty to defend.
Precisely, and that's why Ace picked up the defense based on the other information that was in its possession at the time.
What about the third-party
And that
claims, which
information
assert?
was-
What about the third-party claims, which assert?
Well, those third-party claims weren't filed until after the trial court made its decision in that case, so I don't think that's a subject of this appeal. I think we would have to go back to the trial court if we wanted to look at those within this record. They didn't file any third-party complaint against the employer until after this decision was made at the trial court. So Ace picked up the defense with the two letters that were sent from Con Ed in the city telling Ace that they had performed an investigation and that despite what was in the complaint, they had come to the conclusion that it was Waterworks that was responsible for this accident. So in response, Ace picked up the defense under a reservation of rights with a letter that specifically told them it was going to pick up the tender, but it was going to be specifically
Where is
only
the
obligated.
finding, where's the definitive finding that Waterworks is not, or the employee is not at least partially responsible for this accident? Because for there to be no duty to defend, you would have to show as a matter of law, there is no question that there is absolutely no liability on the part of Waterworks or the employee.
Well, with due respect, I don't think that's the standard. The standard is there a reasonable possibility that Waterworks was the proximate cause of this injury? And proximate cause is a well-developed standard under New York law, meaning what was the legal cause and whose control was that risk within and who could have prevented that?
But what, are you suggesting we have a trial within a trial on this action to determine those issues?
No,
Normally those issues are decided in the underlying action, not in the declaratory judgment action.
I'm suggesting that those issues were before the court when they looked at the pleadings that were available to them, and the only things in the pleadings were that the live wire was the proximate cause of the injury. Any failure to wear proper safety equipment or failure to have safety in their equipment, as is potentially alleged but unsubstantiated here, would only offset
You
that.
just use the word unsubstantiated. Again, we're not making factual determinations as to the underlying incident in this declaratory judgment. So where has there been a determination that the gloves were not a potential proximate cause, with the understanding that there could be more than one proximate cause?
I think you have to look to Burlington and the First Department following that decision in Hanover to understand what proximate cause is, and it is who could have prevented the loss. It wasn't wearing different gloves that could have prevented being electrocuted. Maybe he would have been less injured, but that's not what proximate cause means under the law. The standard is much more than that.
Okay, you have time to rebuttal.
Thank you, Your Honor.
Good afternoon, and may it please the court. My name is Laura Linneball, and I represent Con Edison. In 2012, Con Edison entered into a $111 million.
What about the argument that under the four corners of the complaint, there's no allegation that Waterworks was responsible?
Well, Your Honors had it exactly right. The plaintiff did not make allegations against Waterworks because he couldn't. He's barred by Workers' Compensation Law, Section 11. But there are allegations in the complaint that talk about that Mr. Rodriguez was injured while he was working for Waterworks on this project. So that allegation in and of itself is enough under the Indian Harbor decision from this court in 2018 that Judge Singh was on. It also is similar to the Old Republic decision from 2021 from this court that also Judge Singh was
Did
on.
Burlington change the law at all regarding how to interpret this?
Burlington isn't this case. I mean, of course, I respect the Burlington decision, but in Burlington, it
How
was...
does Burlington impact the argument you're making?
Actually, Indian Harbor and Old Republic were both after Burlington. And those cases said that it just has to be, there has to be a reasonable possibility that that the primary insured might have been a proximate cause of the
So I guess the question is how, your adversary says that that's not shown in the four corners of the pleadings here. How do you, again, address that question?
Well, first, it doesn't have to be shown just in the pleadings. It has to be what is in the complaint and facts that are known to the insurer. The facts that were known to the insurer when it picked up this defense unqualifiedly agreed to defend and indemnify without a reservation of rights was that...
That's a separate issue, which for our time we'll get to, but go ahead.
Was that he was injured on the job. We have raised, and the city has also raised, that there are multiple questions of fact, as your honors indicated, about whether or not Mr. Gonzalez was provided with the correct safety equipment, including insulated gloves and an insulated apron.
Is the coverage action the place to make those determinations, or is it in the underlying action that those determinations will be made?
It is in the underlying action, your honor. We also contend that while the Supreme Court's order was correct, it didn't go far enough, that it should have also awarded indemnification. And that's for two reasons. Because ACE's disclaimer made 3.5 years after it conceded that it knew the grounds for the disclaimer is untimely as a matter of law. And second, that ACE is stopped from denying coverage because it defended and controlled Con Edison's defense.
Why wasn't the reservation at the beginning of the action enough, the language used in the initial reservation, to establish that they were challenging coverage?
And Judge Leibovitz actually addressed that in a decision after this appeal was taken. It wasn't enough because it didn't give Con Edison or the city a, it didn't give them fair notice that the insurer intended to assert defenses to coverage or to pursue a declaratory
Why wasn't the language in it sufficient? Understanding that you don't have to say you don't have to explicitly say reservation of rights, as long as there's some language indicating that they have issues about coverage, why wasn't the language in this sufficient?
Your Honor, because there was nothing to indicate that. There was nothing to indicate.
But the language is based on the current known facts, which to me suggests it's limiting language, saying, hey, what we know now, okay, we have to provide a defense. Why isn't that a sufficient reservation of rights?
The cases that we've cited in our brief say that that is not a sufficient reservation of rights. That boilerplate language is not. Judge Leibovitz also found the same thing. And most importantly, because at the time they made the disclaimer, the facts that were known to them were the same facts that they're now trying to disclaim on. So based on the facts that they knew at that time, they conceded that they had to defend and indemnify Con Edison. And we also were arguing that ACE is stopped from defending or from denying coverage because it defended and controlled Con Edison's defense for 2 years without a reservation of rights, although
We only get to that issue if we agree with you about the reservation of rights, correct? If we agree with you that there was not a reservation of rights.
They did not assert a reservation of rights. Yes, you'd have to get to that. We also believe that ACE's disclaimer made 3.5 years after it learned of the grounds for the disclaimer is ineffective as a matter of law. Under Section 3420 of the insurance law, the carrier has to provide a written disclaimer as soon as reasonably possible. The cases are clear that it can't be any longer than 42 days after they knew or should have known the grounds for the disclaimer. They admit that they knew the grounds for the disclaimer before they accepted the tender. So obviously 3.5 years is unreasonable as a matter of law. There are also multiple other reasons why their argument that a timely disclaimer wasn't necessary failed. There's 3. First, ACE waived that argument by not arguing it in its opening brief. It can't wait to reply to raise it for the first time. The argument is belied, second, by the plain language of Insurance Law 3420, which says that if under a liability policy, the insurer shall disclaim liability or deny coverage, which implies that it means either by reason of an exclusion or by reason of coverage. And importantly, and I'll sneak this in if I can.
No, you have to wrap up. Your time's up.
Okay. The reason.
You have a minute for rebuttal, though.
Okay, thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Alan Rosinas, representing the City of New York. Your Honors, to be clear, because this is a bit of a sprawling case, the issue for the city on appeal, involving the city on appeal here, is only as to the duty to defend. We're not talking about indemnification. And that duty, we win on that unless ACE can show that there is no possible factual legal basis giving rise to coverage, which is the insurance coverage of the city. And that's from the Court of Appeals decision.
Do you agree with counsel that it has to be pled, it has to be something from the complaint itself, or can it be broader?
It does not have to be something from the complaint itself, Your Honor. Under
Obviously,
that same
because that would mean that a worker could never, the worker's employer could basically never get a defense because they're not going to plead a claim against their employer.
Right. Certainly, if it were contingent on the employee pleading a claim, then that would be just about impossible. That's right, Your Honor. But the same case I just mentioned, Frontier Insulator Contractors, the Court of Appeals case, says that there are 2 scenarios where the duty to defend exists. One is where the 4 corners of the complaint give rise to coverage, and the other is it's an or. The other possibility, independent possibility, is where the insurer has, which here is ACE, has actual knowledge of facts establishing a reasonable possibility of coverage. So here we think both apply here, because the fact that Rodriguez in his underlying complaint is talking about the provision of the labor law that imposes a non-delegable duty on both the city, which is the owner, and the contractor, which is Waterworks, which is the primary insured. That means that there is a possibility of legal liability on the part of the insured. Sure, I mean, ACE comes back on reply and says, well, Rodriguez says that the city was solely liable. He can plead that, but his pleadings alone don't foreclose the possibility that there is liability on the part of Waterworks as well. The other key point, ACE is saying that the problems with the safety equipment are unsubstantiated. ACE's own investigation into this incident showed that the jackhammer, that according to Rodriguez himself in deposition testimony, the jackhammer that Waterworks, the primary insured, supplied him with for this job lacked an anti-electrocution bushing, which is a component of the jackhammer that prevents electrocution. So it's not unsubstantiated at all. There's evidence in the record, and in fact, it's evidence from ACE itself.
And no determination has yet been made on those issues.
No determination.
The underlying action.
Right, and that's also important, Your Honors, because, again, ACE only wins if it can show, it has the burden to show that there is no factual or legal possibility that coverage exists. So that's another reason that ACE should lose, and the Supreme Court's order should be affirmed. The point about the bushing is important because it also goes to another argument they're making, which is that somehow, even if all they did was if all ACE did was exacerbate the injury, then that's not proximate cause. That's not true. First of all, because The contract here discusses whether bodily injury was caused in whole or in part by waterworks. Bodily injury. So if the injury was exacerbated, if he had just gotten a mild shock because the bushing was there, but instead he got what he alleges getting here, which is permanent bodily injuries, that certainly is causing the injury in part, at least.
And couldn't there be more than one proximate cause of an
Yes,
accident?
of course, Your Honor. That's basic tort law.
Right?
Yeah.
Could be 3 proximate causes. The gloves, the 10 things could cause it.
Exactly, Your Honor. And all that ACE has to show that there's no possibility that it caused it even in part. And the other thing about the bodily injury that's important is they rely on Burlington. Burlington itself says the question is who approximately caused the injury. So again, all that has to be established for ACE to lose, well, it doesn't have to be established because ACE has the burden. But in effect, if the evidence right now shows the possibility that ACE caused the bodily injury, Waterworks, ACE's primary insured, caused the bodily injury even in part, then ACE loses. Quickly on the attorney's fees issue, Your Honor, they cite this Sukup case on fees. That case is from 1967. So the cases that we're citing from U.S. Underwriters, which relies on Mighty Midgets, U.S. Underwriters is from 2004, Mighty Midgets is from 1979. So to the extent that that conflicts, it's superseded. And Sukup, anyway, is about a different factual scenario where the question is whether there's an extra contractual workers' compensation policy that requires coverage, whereas here the question is whether the contract requires insurance coverage, and that's the issue in Mighty Midgets and in U.S. Underwriters.
Thank you.
Thank you, Your Honors.
What we really need to get to here is not just what the complaint said, but what other facts were in ACE's possession, and then why did ACE change its coverage position? ACE changed its coverage position because new facts came to light, which showed ACE that it had no duty.
What about the allegation about the jackhammer not having an anti-electrocution aspect of it, which would have prevented the plaintiff from being electrocuted? If that's ultimately proved, then there will be liability on the part of Waterworks, and there would be coverage. So how, since no determination has yet been made on that claim, how are you going to be successful in your argument?
Because I think under Burlington and its progeny, that would be a but-for cause, not proximate cause.
Why wouldn't that be proximate cause?
Because and it also goes to their arguments. on the
Assuming there
labor
can be
law
more
case.
than one proximate cause.
Yes, I agree there can be more than one proximate cause, but it also goes to the arguments, and if you look at each one of the labor cases they cited, they only find liability on the employer after it's determined that the claimant's supervisor gave the directions, the work was ordered by the foreman, the electricity wasn't shut, like the
Sounds like a lot of issues that haven't been resolved yet, but okay.
None of these have been alleged. It is clear from the record now that the only way, and this is why ACE changed its coverage position, because the deposition showed after it accepted the tender that that there was no possibility for Waterworks to shut off the live wire.
Thank you.
Your Honors, briefly in reply, Burlington, as Your Honors have acknowledged, says that there can be more than one proximate cause, and it is distinguishable from this case because in Burlington, the named insured, it was undisputed that they were not negligent. Here, there's a third-party action where the city and Con Ed have alleged that Waterworks was negligent in not providing the proper safety equipment, not insulating the jackhammer. And again, I would invite the court to review the record. There's nothing new that ACE found after it accepted the tender fully. There simply are no new facts.
Thank you.
Thank you.
SolidX Management versus VanEck.
May it please the court, Lauren Coppola on behalf of appellants. Appellants filed their first amended complaint after respondents produced about 4,000 new documents that they improperly hid on their nearly 10,000 entry privilege and redaction logs. The FAC added over 50 new paragraphs of factual allegations and 5 new legal claims, because that is where the evidence in the case took us. Appellants asked this court to overturn the Supreme Court's order, which wrongly granted respondents' motions to dismiss the newly asserted claims.
Let's talk about individual claims, because there's broad allegations, but obviously we have to deal with each individual cause of action and whether or not it states a claim. So why don't we start with fiduciary duty, since that's one of the major claims. Why isn't the claim that there's a fiduciary duty barred by the express and clear language in the agreement that there is no fiduciary duty?
Thank you, Your Honor. Well, we know from Martin, which is almost 100 years old, and Rubenstein, up through the First Department's 2005 Sargent case, that contractual disclaimers to the contrary, fiduciary relationships, such as partnerships or joint ventures, may be created by the operative effect of the parties' relationships. And we look
Right,
to...
but here the agreement clearly says there is not a partnership, it is not a joint venture, it's explicit. So how do we get around that?
It is explicit, but it is not dispositive. And so in every case...
But what gets around it in this case?
I'm sorry, Your Honor?
What in this case would make it not dispositive?
So what we have in this case, which is different from Dedco and the other cases that were relied upon by the Supreme Court, are detailed factual allegations of the elements of an implied partnership.
So is there anything that the parties said that they would agree to share profits and losses?
Yes, Your Honor. So that is
What
one of the
document is there that they agreed to share profits and losses?
So the parties had agreed. I'll point the court to the record at 22, paragraph 32 of the FAC, which discusses a 50-50 split of revenues.
No, revenues. What about losses?
So what the contract discusses, Your Honor, is net revenue.
No, I want to know, what does it say that we agreed at some point that we will share our losses? Because that's it.
So, Your Honor, there is case law that establishes that where losses were not contemplated. So what happened is VanEck put in expenses.
Losses weren't contemplated in this case, where a cryptocurrency exchange, and you were spending money to get out?
Your Honor, when it put in revenue, when it put in payment of expenses, and net revenue.
Who
as
said it
defined in the
wasn't?
contract?
Let me ask you this. Let me interrupt you just for a second. Who said that there were no anticipated losses?
I'm sorry, Your Honor, when I said that, I was discussing cases.
I'm not talking about cases. I'm talking about this case, because in this case, everybody agreed in a writing, sophisticated parties doing a cryptocurrency platform, that we are not partners. We are not joint venturers. So we start with that. And you're saying to me, no, the party's intention was to be a partnership. And I'm asking you, who agreed to share all the losses between the parties? Because that's a.
So, Your Honor, yes, the FAC includes a reference to a board memo with Jan VanEck informed his board that profits and losses would be shared 50-50.
Let me ask something. We have an agreement here, and the agreement explicitly says it's not a joint venture, it's not a partnership. So wouldn't you have to show some evidence of some interactions between the parties that supports that there was something other than that was
Yes, Your
in the
Honor.
written agreement? So what is there outside the written agreement that's an actual exchange between the parties that supports the claim that we should go against the very explicit, clear language to the contrary in the agreement?
And the case law supports that you can look behind the
I
wording
get
of
that
the
the case
agreement.
law says that, but where's the evidence in
Yes,
this
Your
case?
Honor. So I will point, Your Honors, to paragraphs in the FAC which articulate that the parties had dealings where VanEck agreed to appear at the SEC, where they informed the world of a partnership, where they had control and input over custody and control of the Bitcoin.
Okay, you have time,
Moreover,
you
they
have time,
agreed, Your
you
Honor.
have time.
Good afternoon, Your Honors. Tom Dewey for VanEck. Justice Schechter correctly rejected new counsel's efforts to ignore what the contracts say and her own prior ruling to try to impose fiduciary duties where there are none and to manufacture a baseless fraud claim against our company and our
Are there
CEO.
any real factual allegations in the complaint that would indicate a sharing of profits and losses that would
No.
create a partnership?
None, Your Honor, because guess what? That was not the deal, and everybody knew that.
Was there ever a reckoning, an accounting between the two parties that said, okay, this month, here's what we have, here's what you pay, here's what I pay? Did that ever happen?
Absolutely not, Your Honor.
Was there any allegation that anything like that ever happened?
I don't believe so, Your Honor. And as the court has indicated, these are very sophisticated parties. One of the SolidX principles is himself a lawyer. And the fact is, you cannot impose a fiduciary duty here.
Well, let me ask you, go ahead.
I'm going to ask a very specific question about the section about breach of the agreement in 1.28, which stated that there was an obligation to provide marketing materials, and those materials were never provided. Why should that be dismissed on a motion to dismiss or a motion for summary judgment, where it's sort of a factual issue whether or not they were produced? And I understand that the cause of action is not pleaded too well because it also brings in breach of duty of good faith and fair dealing. Putting that aside and just talking about the breach of 1.28, why doesn't that state a claim?
Yes. The obligation in the contract is for VanEck to create marketing materials. On the face of their complaint, repeatedly, they conceded that we, in fact, produced marketing materials.
But that doesn't mean, go ahead.
Is the amount of marketing materials, is that maybe the factual issue?
I don't think so under these circumstances, Your Honor, where there's such a clear admission. I'd make two other points on that. First of all, the first agreement contained a much broader obligation to market the intended ETF. The second agreement was much, much narrower. Second point I'd make on that is that the
Don't they allege that you didn't really create the marketing materials you promised to create?
I don't really think they say that quite that clearly, Your Honor. And the fact is the matter is that there are repeated admissions that we were working, quote unquote, tirelessly to market the product. And there are instances in the record where they're directing third parties, go to the VanEck website, that's where the marketing materials are.
No, but this is a pre-answer motion to dismiss, right? We're not looking at the record, and they've said you were supposed to produce good quality marketing materials, and you didn't. That states a claim, don't you agree?
I respectfully disagree, Justice Scarpula, because the complaint says the marketing materials were created. It's a narrow obligation.
It says produced few, if any, of the marketing materials. But why isn't that particular few, if any? I mean, this, again, as my colleagues pointed out, this is a 3211 motion. Maybe on summary judgment, it'll be a little bit different, but it's pled.
Right, but there are other, you're absolutely quoting the complaint correctly, but there are other places in the complaint, like record at 11, where it's clear where we presented the marketing materials, and they acknowledge we presented the marketing materials.
Yeah, but you could produce one shoddy marketing. That doesn't mean you produced the required marketing material. Wouldn't we have to look at the record to determine that, which is a summary judgment motion rather than a motion to dismiss? Because they do allege that you did not produce the required marketing materials.
The contract says we only need to produce marketing materials. If they wanted to have some kind of qualitative criterion about what they need to look like, et cetera, that could have been included in the contract.
Or you could have included in the contract that one piece of paper satisfies this, right? There's no way, either way, that we can tell what would satisfy marketing materials, not by the contract for sure, because it doesn't have any qualitative numbers.
Ultimately, wouldn't that be an issue for discovery in terms of what the custom and practice in the industry is with respect to marketing materials, how much is sufficient, et cetera, et cetera? It's not a decision that should be made on a 3211 motion, correct?
Okay. I understand the point, Justice Singh. I think that
given what's in the complaint and what's they have acknowledged, that that's sufficient for a motion to dismiss, but I understand the point. If I can just pivot back to the partnership issue, as I'll
In
call
your
it.
15 seconds, you can.
I'll talk quickly, Your Honor. Martin is a Court of Appeals case where the Court of Appeals found no partnership as a matter of law. Dedco is a controlling precedent. The case of Justice Scarpulas before she joined this court, which a prior panel wisely affirmed. The fraud claim is a non-starter. The alleged fraud is our failure to disclose something we were allowed to do under
Did
the
you have any obligation to disclose anything?
None whatsoever, Your Honor.
Right. Okay.
Thank you.
Thank you.
If I may start with addressing the issue of losses. So I will direct the court's attention to the section of the agreement which discusses payment of net revenue, which is the amount that is determined by the management fee, subtracting that calculated for expenses. The loss here, Your Honor, were the expenses that the parties put in to run this trust. And the net revenue that was paid to VanEck subtracted those expenses.
So at the time that you drafted the agreement and that was the idea, right? That is what the agreement says. At the same time, it says that we are not considering that as a partnership. So you got to come up with something else than that, because that's in the agreement, and you've both clearly agreed that those.
Understood, Your Honor. And
So what else do you have?
There is a multi-factor test that the court has issued where we've talked to in the
I'm
complaint.
asking you, what facts did
Sure.
you plead?
So we've pled the revenues that VanEck was permitted to purchase the trust, that it had adherence powers where it was able to instruct SolidX that it wasn't properly controlling the custody of the Bitcoin. It participated in SEC meetings. It suggested the fidelity as a custodian for the Bitcoin. It was involved, and these are all allegations, Your Honor, set forth in detail. And if Your Honor would look at record 390, which contains the red line complaint of all the new allegations. Moving on to other issues, but the elements, you have to look behind the language, especially where the FAC alleges that it was nominally named.
So contracts have no meaning under this argument?
No, Your Honor. The inquiry is if the allegations in the complaint allege more than a simple arm's length transaction, you can look behind the words, particularly here where there's an allegation where the GC of VanEck inserted the language so as to not trigger FINRA regulations. Thank you.
People versus Maximo Mazini-Martinez.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Maximo Mazini-Martinez. May it please the Court. Mr. Mazini-Martinez demonstrated at the 440 hearing that he received incorrect advice about the immigration consequences of his convictions.
I ask you to start with the prejudice prong as opposed to the ineffective counsel prong.
Absolutely, Your Honor. Mr. Mazini-Martinez showed that he was prejudiced, and he showed it in two ways. The standard for assessing prejudice is whether there's a reasonable probability that the outcome would have been different. And here, there are two ways that the outcome could have been different. One, if counsel had been focused on the fact that my client was a non-citizen, he could have attempted to negotiate a plea that did not result in automatic mandatory deportation.
Let me ask you something. Didn't he actually testify at the hearing, as opposed to in this motion, that his top priority at the time of his plea was to avoid incarceration, as opposed to entering a plea that would avoid deportation?
He didn't know about deportation. Of course, he would have said his priority was avoiding incarceration. That is the ordinary thing that people are worried about when they're facing criminal charges, is incarceration. The problem here is my client didn't know that he faced mandatory deportation if he
So the attorney below testified that he did speak to him. he may not have told him that it was mandatory, but he said, I told him that if you don't go to jail, the chances are less that you will be deported, or something like that, right?
Right, he didn't
So
say
let's
that.
assume that the trial court's credibility determinations are worthy of upholding. So he does know something about it. He knows something, because that's what the trial court found, that counsel's statement was credible.
I'd like to make one quick distinction here. He didn't say that's what he told my client. He said that under the circumstances here, that's what I would have told him. I don't remember anything about this client or the case. That's what I would have said.
But I mean, that's not surprising, right? You can't ask somebody
That's
to remind. Was 2017, right? Or when was he?
It was approximately 16 or 17, yeah.
Right.
Right.
So, but he said, here's my practice, right? I would have told him that this offense, because you probably, if you're not getting jail time, it's much less likely that you will be deported. That's what he testified to, and the trial court found that credible, right?
Right.
So let's assume that your client knew something about deportation.
I get where you're going with this.
So the question
that would not have
again
been
comes
that would
back.
not have been enough under this court's
Let's
precedence.
Right. That's, I think, why
That would
Justice
not have
Kern
been
asked you to
enough.
focus on.
It says where there are clear consequences, you have to give clear advice. Deportation was mandatory here. Nothing less than saying deportation was mandatory would have been enough here.
Right, but so that's right, why I did ask you about prejudice. Let's say that counsel was ineffective in not telling him this is a mandatory deportation type offense. You still have to show the prejudice prong, that if he had known that, he would not have pled guilty. And there was compelling evidence. He got a no prison sentence. He did have family ties in Ecuador. His wife was still there and child. So there were a lot of factors that undercut the significant prejudice, which is why I asked you to focus on how you have established, assuming counsel was ineffective, that there was prejudice. I'll let you answer.
I would start with I really object to the premise that he knew. The people cite in their brief the pre-sentence report where on the same day that he pleaded guilty, the same day, September 16th, he tells the Department of Probation, once this case is completed, I plan to start the petition process to get them to come to the United States. So he thought on the day he pleaded guilty that once he did his probation, once the case was over, he was going to be able to petition for his wife and daughter to come to the United States. So that's important for two things. Number one, it goes to the credibility finding that this client was advised as to immigration consequences.
You're not even talking about the prejudice, but
let me get to the second
I'm going to let you
point.
respond on rebuttal.
That was the most important thing to him, was getting his
I'm going to let you
family
finish up on rebuttal. Thank you.
into the United States.
Good afternoon, Your Honors. Assistant District Attorney Saad Siddiqui on behalf of the respondent people of the state of New York. Your Honors, the hearing court correctly ruled that the defendant failed to establish that defense counsel Druckmann did not advise him regarding the immigration consequences.
Counsel, how do you reconcile that with what's in the record at the time he took the plea? I mean, the question was asked, are there any immigration consequences? And not that I'm aware of, was the response by the attorney. So either the attorney didn't know there were immigration consequences or never asked his client. I mean, neither one of those two things lends to the, to the thought that he informed his client that there were immigration consequences, based upon his own statement at the plea.
But then his subsequent testimony at the hearing clarified the issue in which Attorney Druckmann indicated that he thought that the court was referring to whether or not defendant was actually in removal proceedings.
There's no evidence in the record that he was actually told, hey, this is a mandatory deportation offense, and if you plead guilty to this, you're subject to mandatory deportation. There's no evidence of that in this record, so why isn't that by itself enough to find ineffective counsel?
Well, Your Honors, I would ask that the court consider the totality of the record and of all of the proceedings, even looking at
Where was he ever told this is a mandatory deportation offense?
Well, I would
He said there might be deportation consequences, very different, and we have a lot of cases about this in the First Department, then, hey, this was a mandatory deportation.
Well, just to clarify, under federal immigration law, there is no actual term that actually enumerates mandatory deportation.
Right, but that's a term of art we've been using in our cases.
Of course.
Where it's that type of offense.
But in this particular instance, what was clear was, and defendant even testified to this at the hearing, he indicated that the defense counsel Druckmann spoke to him about an aggravated crime. And speaking to a very specific term used in immigration law, that was with respect to an aggravated felony, which is a absolutely deportable.
Right, but he wouldn't know that. But let me ask you to address also the issue of prejudice. Assuming we do find that counsel was ineffective, why isn't this record sufficient to establish that there was prejudice to him based on the ineffective assistance?
Well, given the specific benefits that the defendant did in fact receive, not just the fact that he received a non-incarceratory sentence, but what that actually meant for the purposes of actually avoiding being placed in removal proceedings. In 2010, it was very clear ICE actually had an office at Rikers Island. So to the extent that anyone was placed in removal proceedings who was in fact incarcerated, that was done almost immediately. And this was actually borne out by the fact that when defendant was actually taken into custody on his 2014 case out of New York County, he was in fact placed in
Right, but the
removal
notice that
proceedings.
was served about his deportation referenced both pleas, not just the 2014 plea. So I don't know how much weight we can really give that.
But not
what you're arguing right now.
Certainly, but Judge, you could also look at the fact that he did avoid incarceration, and more to the point,
How strong was the case against him?
he had a confession. There was a statement, and he was actually arrested after he tried to cash the second check. There was the first check that he had taken from the car. He forged in $350 in the amount. He cashed it successfully.
And what was he facing? If
He was
he'd gone to
facing,
trial,
he was charged with a D felony top count up to 7 years in state prison. We're talking about two separate transactions or two separate incidents. And he took a pre-indictment disposition to receive the most favorable outcome.
And did he testify at the hearing that his main concern was not going to prison?
That was certainly one of the main concern, that was his main concern, and that was his testimony. He was not looking to go to jail. He was trying to avoid it at all costs, and he did so. He received a favorable disposition, 5 years probation, an aggregate 5 years probation.
So, but let me just clarify with you, the attorney never testified that I told him that this offense was an automatic, we don't have to call it mandatory, because I agree, it wasn't mandatory, but it was definitely automatic, even in 2010. It was a presumptively automatic, and he never testified that he told him that.
Well, certainly he testified that he didn't remember and that
Right.
his practice would have been.
To tell him if you don't go to jail, it's less likely that they will insist on the automatic. But that's not the same as saying this is an automatic deportation offense.
Well, respectfully, Your Honor, I believe what defense counsel advised defendant was that by avoiding incarceration, you would actually then avoid being placed in removal
That is,
proceedings.
if that's what he said, that's not even true. It was totally up to ICE whether to do it or not. He was automatic, once that conviction was, once the fact of the conviction, the federal statute says you are deportable. It's really just in ICE's discretion whether to do it or not.
Certainly whether they're aware of you, and
That's a different thing than saying I would have told him, right?
that is different, but notwithstanding getting to just Your Honor's point about prejudice, again, by virtue of the disposition, he was in fact able to avoid being placed in removal proceedings, and that didn't happen until a subsequent conviction.
Let me see if I can do a better job of addressing your prejudice argument, Justice Kern. There are two ways that this court has found that you can establish prejudice. One is if a better plea offer could have been negotiated, and two is if...
So let's deal with the first one. In this instance, what's a better plea offer based on the confession, based on being caught in the act?
There are lots of negotiations that took place in 2010 and to take place in 2024 to find a disposition that does not result in, for one thing, 2 CIMTs. The problem here was that it was 2 CIMTs, the second one being a misdemeanor. So if there could have been one plea to the felony, a second plea to a misdemeanor, that would not have been mandatory deportation, could have had the same sentence, probation on both, could have been easily negotiated, and negotiations like that take place every day. So that's one way that my client was prejudiced. There's nothing in this record to suggest there was any immigration consequences related plea negotiations. The second way that prejudice was shown here is that the importance of remaining in this country to my client would have affected his decision to plead guilty or not. United States versus Lee says that yes, even the strongest case, a defendant can rationally choose to go to trial, even if conviction is almost certain, if it offers the chance of staying in the country. My client established that he had a wife and daughter who he was working towards getting immigration for them to this country. He had been in the country for 4 years. He had, through his mother's sponsorship, which had taken many years to process, remaining in this country would have been extremely important to him. And that's how we show prejudice here, both as to the focus on negotiating a better plea and going to trial if necessary.
Thank you. Keang.
May it please the court, Emily Wall for the appellant father. Before an agency may seek to terminate a parent's rights, they must first make diligent efforts to help the parent overcome whatever problems are preventing reunification. In this case, the agency failed to do so because they failed to assist.
So what more, and I understand the argument, good argument, but what more under the circumstances of this case, given what we know about the father, his illiteracy, even in I guess, Mandarin, and speaking a dialect, and a father who has to travel for his job as a cook. What more could the agency have done under the circumstances?
Well, Your Honor, in this case, the agency didn't offer the father any service that was aimed at helping him learn about his wife's mental illness, which the agency said was the main issue that was preventing reunification. Their main concern about him was that he didn't understand that his wife's schizophrenia posed a risk of harm to the child, and they were concerned that he might choose to leave the child in the mother's care. So they should have referred him to individual counseling so that he could learn about what that means and how the diagnosis of schizophrenia affects his wife's ability to care for the child appropriately. In addition,
Wasn't he referred, he was referred, I think, for parental skills training, right?
He went to, yes, he was referred to a parenting
So wouldn't
class.
that be, frankly, and it was in Mandarin as well, correct?
It was in Mandarin, yes.
So wouldn't all that be covered under the parenting skills? Would obviously also include concerns about the wife and her mental status?
Well, the parenting class was a general parenting skills class. It wasn't tailored to his specific circumstances. It wasn't, I don't believe there was any evidence that it addressed issues like mental illness or schizophrenia or how that would impact a parent's ability to care for a child. It was probably talking about baby's development and, general information that new parents would need. In addition, it took the agency 2 years to refer him even to that class, which was the only service that they referred him to before filing the petition to terminate his parental rights. They also did nothing to assist him with overcoming the obstacle that prevented him from visiting more frequently with the child. As the court acknowledged, he worked out of state frequently for weeks at a time.
They gave Metro cards, but they didn't pay for bus fare.
Yes. So he was often out of state as far away as Virginia, Ohio, Boston. He wasn't able to come back as frequently as the agency would have liked to a visit with the child, and they didn't offer him anything to assist him with overcoming that problem. They didn't.
Bus fare, or what are you suggesting they should have offered him?
Well, yes, bus fare would have assisted. He had, I believe he testified, he worked 6 days a week, so he had 1 day off, which I believe was typically Mondays, which was why the visits took place on Mondays. And they didn't offer him bus fare coming back and forth, but
Is that
also...
your argument, though, the bus fare? I mean, is there anything else to that argument?
Well, I would also say, Your Honor, that the agency could have assisted him perhaps with finding employment in New York City so that he wouldn't have to travel so far.
Is that what the cases require? I mean,
Is that what ACS does? I've never heard a case where ACS is helping people find employment
Well, Your Honor,
as part of their services.
there are cases where the court indicates that the agency should have assisted the parents with the underlying problems of unemployment, underemployment, financial security. When those are the problems that are preventing reunification, the agency is required to assist with those problems. And there are regulations, 18 NYC RR 423.2, which specifies that vocational diagnosis and training, employment counseling, those are things that an agency can provide to parents.
So in the record is a reference that the father attended the mother's therapy sessions, right? And because the agency requested him, he knew that she had schizophrenia. He knew that she was required to take mental medication every night, which she wasn't taking for periods of time. So what more do you think he went with his wife to therapy sessions? That's in the record. So what else is there that you think that the ACS was supposed to do?
Your Honor, I don't believe it's in the record that he went with his wife to her therapy sessions. The case planner testified that she spoke to the mother's therapist, and the mother's therapist said that she had informed the father that he could attend the wife's therapy with her, but the mother didn't attend therapy regularly. It was clear throughout the record that she did not consistently attend therapy. So
But he knew she had schizophrenia.
he knew, I don't know if he knew that word. He knew that she had a mental illness and that she was required to take medication.
Thank you.
Good afternoon, Your Honors. Jeffrey P. Berman, appearing for Good Shepherd Services, the respondent. Your Honors, I think really the main question here is, what would realistically have made reunification possible between this?
Well, how about what counsel said is providing regular bus fare once a week, maybe helping the father with employment in New York City. There's a large Chinese Asian community here. Are those things that the agency does?
Well, I mean, the agency does what's reasonable, right? So providing bus fare from Virginia a couple times a week, I don't know how reasonable that is. I think the father should have, I mean, they could have, in terms of employment in New York City, generally they don't find employment in New York City. If he had asked, he showed no initiative to actually find other employment. He and the respondent mother, they worked together. They worked out of state. They went to all different states to do their jobs. I mean, you could argue that they chose their employment over the child because they really
Counsel,
chose.
My concern is the language barriers that this father faced, and when services were offered eventually, it was basically because there was a long time trying to find someone who could speak the language or the dialect that the father spoke. Is there anything that there should have been more effort there? Because even when the services were offered, I think they were in Mandarin, and he spoke a specific dialect. He was illiterate. He couldn't read in a certain. One of the things was that he should learn English, but I mean, he didn't even really know the language which he was born into.
So the Mandarin is it's a much more common language. It's my understanding than Fuqiao. Much easier to find programs in Mandarin, ESL classes in Mandarin. So the agency did encourage him to attend an ESL class. I believe in his testimony he acknowledged he was told he needed to learn English, but you know, I think it's pretty clear that he refused. He just did not take the initiative to learn English. He put the onus upon the child. The child should learn to speak Chinese. You know, this is an infant child. The agency, I believe, Your Honor, also had asked about the parenting skills program, why it took so long. Again, it was because it's hard to find services in Mandarin. Even though there is a large Chinese population in New York City, it's still not very common to find those services, and interpreters as well. Also going towards the argument about the child being placed in a Chinese-speaking home, incredibly difficult, right? Like, I mean, in my 25
But then,
years.
even if those things are true, I mean, as your colleague on the other side says, it seems like you're putting all of that on the, what's the agency's diligence in that? That's all, you're putting that as to be negatively impacting the father, when what could he have done when you're not even offering the service? You're not doing more to find these services for him.
Well, the agency encouraged him to attend these services, and I think the testimony showed that the parents' work schedule did not allow for them to take these classes. So it's hard to say the agency would have had to.
Well, then I guess it goes back, why not help him find a job in New York City?
Well, he didn't really ask for a job in New York City. He didn't say he wanted to.
An illiterate man, essentially, from another culture, trying to navigate his life in America. Isn't there an obligation on the agency to have a service plan that meets his needs?
Yeah, I mean, I think that is certainly important. It would have been easier if he had a job in New York City, for sure. He would have been able to visit more frequently. However, there are a number of things that he also refused to do, right? He didn't acknowledge the mother's mental illness. He wouldn't separate from her. He would not, while he attended the parenting skills program, he still, even after doing that, he still didn't acknowledge her mental illness. He didn't express any interest to visit more frequently. There's nothing really in the record to say that he wanted to visit more than once a month. He wanted to visit once a month. He was sort of pressured into visiting twice a month, and even then he would leave a half an hour early from those visits. And it would be impossible for him to bond with this young child. This was an infant, him visiting only once a month. It would have been impossible. And I know that perhaps if he had a job in New York City, maybe he would have come more, maybe he wouldn't have. I mean, he really didn't show any desire to
Does
visit.
the agency, in other cases, provide aid for folks getting jobs in the city?
Sometimes they will refer to an employment agency or something like that.
Was that done here?
I don't know that it was done here. I don't think he ever requested employment in New York City. So I didn't see anything that it was done here, but they did make numerous other efforts in terms of the setting up regular visits, the parenting skills program, communicating with his therapist, referring for dyadic therapy. They invited him to the child's IEP meetings, invited him to, I think it was maybe 8 conferences with the use of interpreter services. They spoke to him on the phone through an interpreter. I think the diligent efforts were made, and I think it was really his failure to plan that made reunification impossible.
Thank you.
Thank you.
May it please the court, the Legal Aid Society by Andrew Ford on behalf of the child. I would like to start by stressing the fact that the agency did its best to work with a parent who was in difficult circumstances. Yes, he was illiterate. Yes, he did not speak English. Yes, he had to travel for work. However, the statute only requires diligent efforts, which is defined as reasonable attempts. And this court previously opined in the matter of owed children that diligent efforts are subject to the rule of reason. The appellant father worked. He worked with an employment agency. The record established he never asked the agency to find him employment in New York City or anywhere closer to New York City.
Is that his obligation, or is it something that the agency should also raise because of the difficult circumstances?
The agency is obligated to make reasonable attempts to assist the appellant father. The appellant father never identified employment as a barrier to reunification, nor did the agency. He had a job, he maintained employment, traveled interstate for those employment, for those jobs. He never expressed that the reason he could not visit more or could not come back to New York City more often was because of his job.
The child has special needs, correct?
That is correct, Your Honor.
Did the father make any efforts to address the special needs?
The appellant father did sign the necessary consents for early intervention evaluations and for CPSC services through the Board of Ed. Additionally, he did attend meetings with regards to early intervention and CPSC services.
Did he have a plan? Did he have a plan for if the child was reunified of how to deal with the child's special needs?
No, Your Honor. The record is silent as to what plan, if any, appellant father had to address the special needs if he was reunified. With regards to reunification, his plan when he was working was for initially the appellant mother to care for the child, which, as previously discussed, Appellant knew that his wife had a mental health diagnosis, knew that it was inappropriate for her to be a primary caretaker alone, unsupervised, given not just her diagnosis, but also the child's special needs. He was nonverbal, then he was minimally verbal with extensive needs. The identification of the fact that he could not acknowledge that his wife should not be alone with the child given her diagnosis was the primary barrier. Whether or not the agency could have done more to assist with employment or preemptively identify child
Therapy,
care.
would therapy have helped that situation where a therapist could have explained in the appropriate language why it was inappropriate to leave the child with the wife?
Anything is possible, Your Honor. However, I would note that in this particular case, appellant father did do the parenting skills, but he only attended half of the sessions. He did not even complete the entire program, although he was given a certificate, thus demonstrating to the agency that his ability to commit time to services was limited. As such, since he did not have his own mental health diagnosis, the agency crafted a plan to address his availability and his needs, which was for him to accompany the appellant mother to her mental health services to sit in on those sessions to better understand her diagnosis, rather than requiring him to commit to weekly sessions with a therapist, which, based on the record, it appears to not have been able to do. And I would submit that was reasonable in this particular case, given these circumstances. And with regards to I apologize, I lost my train of thought. With regards to the fact that he did not understand the child's special needs, while that was not necessarily a primary barrier to reunification, that failure combined with his failure to recognize his wife's mental illness combined demonstrated that he failed to gain any insight at all, given the minimal services he complied with.
Thank you.
And I just want to address a few things. First, the agency never referred the father to an English class prior to filing the petition to terminate the parental rights. The case planner testified that she did not refer the father to an English class. That only came up at disposition. The agency never told the father he should separate from the mother. The dyadic therapy referral, that service was not put in place until the same month that the petition to terminate parental rights was filed. And the father was never referred to a parenting with special needs class, even though that had been ordered.
Under the circumstances here, given the fact that he's working out of state, the agency is in a very difficult position to try to provide what you're saying, those kinds of services. So isn't that a factor we should look at, just the circumstances of the father and the fact that maybe he did not make requests about employment in New York, et cetera, et cetera?
So whether the father requested a certain service is not relevant to the determination of whether the agency made diligent efforts, because the agency is charged with determining what the particular problems are and making affirmative, repeated, and meaningful attempts to help the father overcome those problems. And here they didn't do so.
Thank you. Lowe versus Lowe.
May it please the court, Jeffrey Newman for appellants. Every one of appellant's 8 core legal arguments is compounded by the fact that Mr. Lowe was not afforded due process in the underlying proceeding. The lack of due process not only significantly prejudiced Mr. Lowe, but also makes this fair appellate court's review of the ultimate issues impossible. And the lack of due process was abundantly evident as Mr. Lowe, who had court-appointed counsel, admitted to sabotaging his own client. He unilaterally overruled his client's expressed wishes, his expressed desires, by acting in and advocating in manners that were contradictory, even going as far as adopting the position and evidence of his adversary. The fact that he had court-appointed counsel and that he was an adjudicated incapacitated person increases the importance of his advocacy and never lawfully allows for him to go rogue. The Court of Appeals in People v. Alvarez articulated that the standard is whether counsel, and I'll quote, failed to provide meaningful representation, and quoting again, even in the absence of a reasonable probability of a different outcome. Inadequacy of counsel will warrant reversal whenever a person is deprived of due process. I mean, it means that court-appointed counsel had to be a champion of Mr. Lowe's advocacy. In the facts in this case, the evidence that's before your honors, it is abundantly clear that he was not. And the lack of due process doesn't just end with his admitted sabotage of his client's expressed wishes on the record, on trial transcripts, warned before the trial court. But it also shocks the conscience knowing that this immoral annulment proceeding was carried out while Mr. Lowe was in the hospital intensive care unit, kept alive by artificial means, again in contradiction to his expressed wishes and desires, being caused to intentionally suffer and knowingly intentionally suffer while the successor guardian ignored the medical advice of Mr. Lowe's physicians to sign a DNR order, to sign a DNI order, or to transfer him to comfort care. This goes against...
Is any of that a part of this appeal?
It is, Your Honor. It's part of this appeal.
No, this appeal is about the marriage being annulled, correct? Does it have anything to do with the DNR?
Well, while this annulment proceeding...
I'm asking you, is there a point of law about the DNR or any of that in?
Yeah, absolutely, Your Honor. So the point of law is that the Court of Appeals, in the matter of In Re MB...
Could you focus on the annulment of the marriage? Because that's what I think is the big part of this appeal.
Sure. I will absolutely focus on the annulment of the marriage with the understanding that every component of that is affected with this judicial court's review, the appellate court's, by the due process that was missing from Mr. Lowe. As far as the annulment proceeding it goes, we argue, and it's our position with the court, that there was no decision. It is very clear that there was no decision on the record, and the order that purportedly annulled the marriage was issued post-mortem. That's essentially the order that was issued points back to the decision, the alleged decision on the record, and the alleged decision on the record points to that a decision will follow.
That's true, don't we have the ability as an appellate court to independently look at the record, which is quite extensive in this proceeding, to make our own independent determination as to the issues resolved?
Normally you would, Your Honor. That's right. You could go ahead and comb the record. But that's, again, the problem with the due process issue, that Mr. Lowe was not...
That's not a due process issue. That's what the judge did or did not do. That has nothing to do with counsel's representation. What the judge did or did not do in articulating the decision on the record or in the written order has nothing to do with the due process arguments you're making to our court.
Right, except that if you're asking to comb the record, you mean to go back between the extensive evidence that was presented to the trial court, and we submit by the court-appointed counsel's own admission, he did not advocate for his client. We submitted
Counsel, the law is not just that you do whatever the client says to do when they're been deemed incompetent. It's not that if your client says one thing, you do it no matter what. You have to make an independent assessment whether it's in the best interest of your client. So you don't just do whatever your client says to do. It's not like a guardian for the child. They have an independent duty to make their own good judgment whether it's in the best interest.
The distinction that I draw, and rather than incompetent but adjudicated incapacitated, the distinction that I draw
that's my misuse of language.
The distinction that I draw is the successor guardian allegedly brought this annulment proceeding in the what we can assume is the successor guardian's belief of the best interest.
I'm going to let you address this in rebuttal. Thank you.
Thank you, Your Honors.
Good afternoon. I'm Fran Hoffinger. I represent the respondent, the successor guardian, Catherine Huang. I guess I don't have to address the due process issue unless you would like to speak to me about it, ask me questions, but I
I think
just
you should
would.
address it.
I'm sorry.
I think you should address it.
Okay, well, I'd like to talk about the fact that this court, in matter of Edgar VL, deciding whether or not Mr. Newman's client, Judy Mock, should be removed as guardian, and whether or not Gary Elias, who was the court-appointed counsel at the time, should be removed.
Right. But moving on from that, I guess counsel's argument is somehow that because successor counsel didn't do what the adjudicated, incapacitated person wanted, he was not afforded due process. Could
Okay,
that,
well,
I mean, I don't think that's the law if you.
It's not the law, and
Right.
it's not what happened. What happened was that it's very simple. First of all, by the time the hearing took place, Edgar Lowe was not in any shape to make any decision. And in fact, he wasn't in any shape to make any decision at the time that he purportedly signed a prenup and was taken to a surprise marriage at City Hall. So we're talking about someone with rapidly progressive dementia. That was what was diagnosed in early 2019, that had gone back for many years. By the time Mr. Lowe came before the court again for the annulment proceeding, which, by the way, had been stayed because Mr. Newman's client had issued a stay so that she could intervene in this action. That further delayed, but the order to show cause and the petition for annulment took place while Mr. Lowe was.
So your position is essentially that simply because the successor guardian, successor attorneys didn't do what the incapacitated person wanted doesn't at all establish a lack of due process.
Absolutely, it doesn't, and you all ruled on that.
But could
We had an extension. Why don't you address the issue of the authority of the court to actually issue the order after the death of,
I'm sorry, about the issue.
after the death?
Okay, so so here's what happened. There was a very extensive hearing, which was thoroughly briefed, 6 days of testimony, which took place over a 3.5-week period. Everyone had full opportunity to present whatever witnesses they wanted, cross-examine witnesses. In fact, Mr. Duboulet.
I guess my argument's very specific. There is case law out there that when someone dies, all proceedings
Absolutely.
must stop. So how do you get around that?
Well, first of all, the mental health law, Section 81, does not say that everything ends at that point. The Supreme Court retains jurisdiction. The guardian, in fact, still retains the powers to finish what had to be done. We had a hearing that ended and a court that made a decision on the record. And in fact, misleadingly, the appellant's position is that the judge only said, I will annul the marriage. But 2 pages later, she said very definitively, I am annulling the marriage. I have annulled it.
Didn't the court also make determinations of credibility here?
She did make a credibility. In fact, she made a finding on the record that both the witnesses brought in by Rashida Nasiri, the non-wife, I guess, were not credible. She even stated some of her reasons why they were not credible. She said she would follow it up. And by the way, in many cases, including in Camanester, the decision was rendered, the written decision was rendered after the death of the IP. So that doesn't
it's your position that it's really just a ministerial act of
Yes, it was a pure
documenting something that's on the record?
Yes, thank you, Your Honor. It was a purely ministerial act. And by the way, just for the record, at the time, that we didn't have any notice that Mr. Lowe was about to die imminently. He had gotten somewhat better, and that's what it is. He was an elderly man with health issues. So I just wanted to say about Mr. Duboulet. Mr. Duboulet cross-examined witnesses, and to expect Mr. Duboulet to allow the continued financial exploitation of his client, who was in no position to defend himself, frankly, that would just be outrageous and I think unethical. Do you have any other questions for me?
No, thank you very much.
Thank you.
Good afternoon, Your Honors. Frank Santoro. I represent Allison Lowe, who is, Edgar VL's sister, not his estranged sister, as we read in some of the briefs. Allison actually spoke with her brother frequently. She commenced this guardianship proceeding in an effort to protect him at the outset. She was his attorney, in fact, at some point, and she did have a relationship with him. I just want to make sure that's clear. I think I can speak directly to the issue of the authority of the court to issue the order annulling marriage and voiding the prenuptial agreement. You see, when an incapacitated person who's in the care of a guardian dies, the powers of the guardian are circumscribed under Mental Hygiene Law, Article 81.44. The jurisdiction of the court doesn't end. The Supreme Court's jurisdiction continues over the guardianship and everything that's going on in the guardianship. But the guardian's powers are circumscribed. Except here, right out of the gate, Kathy Wang, as the successor guardian, was given the power to, and this is under Mental Hygiene Law, Article 8121A20. She was given the power to continue to maintain, prosecute, or defend any proceeding or action until the appointment of an executor or an administrator of the estate.
And the hearing had already been completed at that point.
Correct.
And a decision issued, whether or not it was adequate is another issue, but a decision.
Right, the court has the power to look at the record, look at the findings that were made, and go back and say, this order is consistent with the record under CPLR 4213. But I think the important part here is that the guardian's power in this proceeding to annul the marriage and address the prenuptial agreement continued after Edgar VL's death. That she was, in effect, as she was during Edgar's life, she was his estate representative for the purposes of the annulment proceeding and addressing the prenuptial agreement. So that's where the power for this proceeding to continue continued. Even if it didn't, it was a ministerial act, as we just heard. On the issue of due process, Edgar VL's champion here was the successor guardian. She stood in his shoes and she was righting a wrong in prosecuting this proceeding. The duty of an attorney for an incapacitated person, especially someone like Edgar VL, who had these issues, he had lifelong schizoaffective disorder, he suffered from progressive dementia. He, as you can see from the witnesses, from the court evaluator, from Dr. Kasner, from his behavior at the hearing to determine whether he could even consent to a guardianship proceeding where he called Judy Mock his wife. He was not in a position to be giving direction to court-appointed counsel. Kathy Wang was there standing in Edgar VL's shoes and bringing this proceeding to right the wrong that was the marriage and the prenuptial agreement.
Thank you, and we are very familiar with the record. At least two of us were on the prior proceedings, so.
Thank you.
Familiar.
To address a few of the points raised by my colleagues, if the court-appointed counsel is equated as equivalent to a successor guardian or a guardian for an incapacitated person, then there would have been no point for the court to appoint counsel in the first place. The idea that somebody is adjudicated incapacitated, Article 81 is very clear that you still follow their expressed wishes and desires to the maximum extent that you are able to. As far as the idea of the death not divesting the court of jurisdiction, yes, 8121 does have that provision that allows post-death arguments, compounding with due process, what I already talked about. But it does have the provision until the appointment of the executor. But there is an absolute fundamental difference between an action on and behalf of an individual versus an action adverse to your ward. 8121 does not have blanket authority to do whatever you want after.
How was this action adverse to Edgar?
It was
especially under the circumstances here, where early on the concerns about the marriage being maybe a sham, and the prenup being frankly completely disadvantageous to Edgar. How you explain to that to me?
Right. It was adverse to him because it was against his wishes. Whether or not, and he expressed routinely through the years, expressed that this is the woman I love, this is the woman that I want.
Although isn't that exactly what the court found was not borne out by the testimony, and the court made credibility determinations about that.
I'm glad you asked about the credibility determinations because the case law is abundantly clear. What the best that can be argued on the July 17th was that there was an ultimate conclusion made and 2 credibility determinations, not the decision about the ultimate facts that supported the court's alleged decision. And the case law is clear that credibility.
But we can look at the record and
right. And what you'd see in the record, Your Honor, besides the again, I'm going to hit the due process argument that the record's incomplete because there was an adjunct failure to advocate. But what you'll see on the record is that 2 days prior to his marriage, when he was not hospitalized in October, and that's very important because this guy has a complex history, and when his medication...
We're very familiar with the record. Thank you very much, and we'll review the papers.
Thank you, Your Honors.
Mazone versus Alonzo.
May I ask Ms. McAvoy to come up here so she can nudge me or make me a note?
Of course.
Something on her argument.
Yeah, you're on the wrong side, though. You're on the wrong side, though, yeah.
See?
That's why you need her.
That didn't take long. May it please the court, my name is Mark Alonzo. I am an appellant and a defendant pro se. Because of the limited time, I want to make clear, we didn't move for recusal based on bias. We didn't move based on intemperate comments. I've done this a long time, and that's normal. The reason we moved, and I'm not going to go through all the sites, but there is a policy that we, at every turn, attempt to invest our proceedings with no partiality, and even the appearance of partiality is to be avoided. And I can go through case after case, but it focuses on certain issues, particularly where the judge has evidence in his possession and has beliefs about an industry where he's obtained that outside of the sphere of evidence from the case, which happened here. Number 2, it's particularly...
Didn't he state on the record that he would decide the case at trial just on the facts?
Yes.
Before him, and disregard any statements he may have made
Every
during the summary
case
judgment?
that has been reversed where there's a recusal, the judge has said that in the lower court. And it said, yeah, but we have to avoid the appearance. So, and that's, by the way, the Wiggins case, I think of the 3rd Department, where they said, yeah, you can look at the comments. And I said I wasn't moving based on intemperate comments, but the comments are so strong, including to this panel, that you can't feel that there's going to be a fair shake in the trial. And let me tell you why. Because his beliefs about that he derived from family or friends or another case, he makes references to CFAs who are chartered financial analysts, not FAs who are retail financial advisors. Retail financial advisors deal with customers. Analysts deal with hedge funds. So clearly he got the information from somewhere else. He doesn't believe that if you don't produce for your brokerage firm, you won't get fired. He doesn't believe that if your employment terminates and you have been given a recruitment loan, that you are going to ultimately have that loan recollected. Now, why is that important to me defending this case? Because there are doctrines, my defenses, which center on the issue of risk. As lawyers, you can't have malpractice if every single course of action is going to involve risk. But the judge doesn't believe that. He doesn't believe she would ever get fired. He doesn't believe that she'd ever have to pay back her loan. And he said so multiple times. In addition, she assumed the risk because she knew she'd get fired if she didn't claim her ex-partner's business, those clients. So she laid claim. But the judge can't decide that because he doesn't appreciate that she was actually trying to save her career by taking those actions. Another thing is that you look at the ultimate outcome. Yes, you suffered an award against you in the arbitration, but you didn't pay back a $741,000 note. You kept $43 million of your ex-partner's business, which you wouldn't have had but for the strategies employed. And I wanted, because the light's on, and we told him this when we settled judgment, when we tried to put in a re-argument motion, canceled the oral argument, recusal motion, decided minutes after the reply was finished, canceled the oral argument. And he actually said repeatedly, and these quotes are in there, that he was going to ignore the expert witnesses. He said, and that's the problem with this argument. It's also the problem with the expert report that you proffer, is the advice is dead wrong and not colorable. You can't, if you're the judge, and everybody, Mr. Freeman's client was worried she would be fired, knew that the note would get called in. The experts we put in, the only experts with FINRA experience, they said, yeah, that's what happened. She didn't have enough business. In her own life, she only in 17 years had gotten $5 million in client assets. She took from her partner $43 million. When this was questioned by my ex-partner, he said to her, it just makes me wonder, like, how familiar are you with the way this industry works among CFAs? They're not CFAs. We never talked about CFAs. He obviously got the information elsewhere. But the biggest one, because I want to get on to the two other issues because they're equally important. One, he actually, in oral argument, sent a message to say, I'm not going to be partial when I hear this case, if it ever comes back to me. Because he wrote, and it's quoted in our brief, and I was saying, for the purposes of the panel on 25th Street, that she, meaning my ex-partner, would not be successful in making that argument to me. The argument she was making is that we're not guilty of malpractice. So if you go in saying, yeah, I don't care if you reverse the motion for the award of summary judgment, you're still not going to win. That suggests that he's not going to be impartial.
Okay, I'm going to let you make your other arguments on rebuttal. Thank you.
Okay, thank you. Those other two will
But
come.
we also are
I know,
familiar
I
with
will-
the
I will
papers.
cover them as briefly as possible.
May it please the court, Michael Freeman for the respondent. I find it very curious that in Mr. Alonzo's argument, he doesn't cite the standard of law, which is that the absent a statutory basis for disqualification, the trial judge is the sole arbiter of recusal.
And yet there are instances where we reverse, where a judge, so they are the sole arbiters until they're not.
Absolutely, Your Honor, but it's also true that the trial judge's decision should not be lightly overturned. I'm not going to address all the mischaracterizations of the record or the oral argument that Mr. Alonzo has presented here today, but what I will say is that he is conflating the two standards that a judge may consider when he makes the decision whether or not to recuse. The first one is whether there is bias, and the bias was created outside of the record. And the other prong is when the judge has personal knowledge of disputed facts. Now, what Mr. Alonzo's argument is, he conflates those 2 points. He says there is bias, there's no bias. He says that the knowledge that the judge has of the facts of this case are from his experience outside the record. And there is no case in this court or any other court that says a judge must be limited, must take all his life experience and prior judicial experience and check that at the door.
Right, but then there aren't always situations where judges might say on the record, this is what I know, this is how I'm dealing with things. I mean, where do we draw the line?
We draw the line when the judge sits as the trier of fact at a trial. And the reason there is a bench trial here is because the retainer agreement that my client signed with this firm had a no jury clause in it.
So do you agree with counsel that the trial judge basically said, your expert is wrong and there's no way I'm going to credit that testimony?
No, absolutely not.
Absolutely
not. All the information.
Assuming that was all the expert testimony that's going in, right? Did you put in an expert to say something else about that point?
100%, Your Honor. We put in an expert that talked about the contract that my client signed with her ex-partner, which talked about the fact that upon her release from the firm, her termination from the firm, she was going to get $1 million and agreed not to solicit for a period of 2 years her former partner's clients.
Counsel
Right, and what I
read something from the record that said, the problem is your expert is wrong.
Right.
My question to you is there competing expert testimony on that point that would make the judge be able to say that or not?
What I would say, Your Honor, is that all the experts that were submitted by the defendants were all FINRA industry experts. And
Again,
it is
but that doesn't answer the question.
I'm getting there, Your Honor. I'm getting there, Your Honor.
Okay.
And the FINRA industry expert had nothing to do with the malpractice. What my expert concluded was that there was a breach of the duty to advise my client on the solicitation of clients after you sell your share of the business. So what the judge, I believe, was saying is that all the expert testimony regarding FINRA regulations, what CFPs require, have nothing to do with this case, which is why I believe the trial judge originally granted summary judgment. Now, this court reversed, and so defendants are going to have the opportunity to present at trial their experts. And the judge is then going to sit and listen to my expert, who says that all the FINRA regulations have nothing to do with this case, and it all has to do with the contract and the non-solicitation clause, and that the defendant's advice with respect to the non-solicitation clause was 100% wrong. And if they want to put in something that's completely tangential and talk about what FINRA required and what brokerage regulations required, they're entitled to do that. And then the judge will decide that as an issue of fact. But he never said, I'm going to reject the experts outright. He said, based on the record in front of me, he was accepting my expert testimony, determined that there was no issue of fact based on that. This court reversed, so we're going to have a trial on that. So I did not put in an expert to respond to his expert's point that we believed was completely irrelevant to the malpractice. I'll briefly address the subpoena issue.
We only have 4 seconds left, so it's okay. Thank you.
It's fine. It's all in my brief. Thank you.
And if you didn't think the judge was set in his mind about this, when this court reversed the lower court's order of summary judgment, he rewrote it. Because in his decision, in your decision, you said, well, there are issues of fact exist as to whether inter alia, and then you listed a bunch of reasons. Except the court said, this court identified as issues of fact for trial and listed those, thereby eliminating every other issue. That's one problem, which needs correction separate from recusal. But in addition...
That's a legal issue, and if in fact the judge does that, if in fact we deny your motion, then and you go through a trial, that will be preserved for appeal, right?
Oh, no, no question. What I'm trying to do is, and honestly, $741,000 that we saved her, not to mention every other thing, is bigger than the damage award. So on its face, there shouldn't be malpractice. But he is actually, recall, dear, that we made a claim for legal fees, which were not paid. We got sued for malpractice and breach of contract by Ms. Mazone. We counterclaimed for our legal fees. When this case came back, well, when the judge awarded summary judgment, as you know,
We're familiar with the record, counsel.
he automatically took out my legal fee claim. Now, the reason that's important
Counsel,
is you
we'll
are
read
aware
the-
of that.
we'll read
Okay,
the-
I won't belabor that, but also I want to
No,
point
thank
out-
you.
Thank you for your time. Thank you.
Yeah, I got you.
Yeah, Cap was saying. He was saying we gotta try to keep that full stool, the big one, off the wire.
Yeah, because if it hits it,
Yeah, so I just pulled it back. So.